day. We will now have our penultimate session of the day, and it is on the topic of investor-state arbitration. The session has been sponsored by Messrs. Christopher and Lee Ong, Malaysia Advocates and Solicitors, and it will be chaired by Mr. Ong Chi Kwan, who is a partner at Messrs. Christopher and Lee and Ong. Mr. Ong has a stellar reputation in the arena of arbitration and is widely regarded as one of the country's go-to practitioners when it comes to shipping disputes. So without further ado, could I invite Mr. Ong Chi Kwan onto the stage to commence this session.
Thank you very much, Greg. Now, these sessions will be dealing with the investment treaty arbitration. We have been allocated an hour, which will be finishing by under your schedule 3:30. We are now 3:05, so I think we may just go straight to question and answers. But having said that, what we're going to do is I will first invite the three speakers up: Professor Chester Brown, Ms. Harpreet Kaur, and Mr. Hussein Harim. Please take the seat up at the stage. Thank you. Now, all the speakers, I've spoken to them. They have very kindly consented to me dispensing with the detailed introductions. You have their profile in the handout. What I'll tell you is that Professor Chester Brown of the University of Sydney and Barrister of 7 Wentworth Zaborn Chambers will be speaking on investment treaty arbitration with a focused discussion of the content of substantive standards of protections such as fair and equitable treatment and expropriation with regional case studies. The second speaker, Ms. Harpreet Kaur, will be dealing with trends in regional bilateral investment treaty and free trade agreements negotiations, overlapping treaty negotiations, and she will provide us with an update on the Trans-Pacific Partnership negotiations. Well, the last speaker, Mr. Hussein of Widders LLP, will discuss on the growth of claims by investors in the Asia-Pacific region and whether there is a regional or Asian approach to investment treaty arbitration. So without further ado, I will call on the first speaker, Professor Chester Brown, to deliver his paper entitled The Protection of Foreign Investment Under Public International Law. Where are we and how did we get there? Professor.
Good afternoon. Thank you very much, Chi Kwan, for that kind introduction, and thank you to Chi Kwan and also to Sudha for kindly inviting me, and the rest of the conference organisers for kindly inviting me here. It's a great pleasure to be here in Kuala Lumpur with some old friends from the world of international arbitration and meeting lots of new friends as well. Now, the protection of foreign investment is a very topical issue at the moment, given the current debates about the negotiation of two mega-regional trade investment agreements, which have been mentioned by a number of other speakers already today. The two really that are in the headlines are the TTIP, the Transatlantic Trade Investment Partnership, and also the TPP, the Trans-Pacific Partnership. Now, these new agreements, as I think all of you in the room will know, are not bilateral investment treaties per se, but they're broader free trade agreements that cover a whole range of disciplines and have chapters on things like trade in goods, trade in services, harmonising customs procedures, rules on government procurement, etc. But they also contain chapters on the protection of foreign investment. Now, there's been a fierce debate that's been raging for quite a while, and it's really been heightened with the negotiation of these two FTAs, particularly about the inclusion of the investment chapter. But the debate is really focused not on the investment chapter itself, but rather on the inclusion of a particular provision in the investment chapter, which is known as the Investor State Dispute Settlement Provision, or ISDS, as we've seen it talk about. And this is the provision that will generally enable a foreign investor to bring a claim directly against the host state of the investment in international arbitration without any need to go to the local courts of that host state. And it's these provisions that have generated such strong feeling. Now, if we look at some of the, just looking at the past few weeks, some of the headlines that have been displayed around the world in the negotiation of these treaties. Le Monde, the leading newspaper in France, of course, there's an op-ed written by a range of political leaders and trade union leaders saying La France doit dire non, no to ISDS in the TTIP, which is currently being negotiated. An op-ed writer in the New York Times has described the Trans-Pacific Partnership as little more than enhanced corporation power branded as free trade. It gives corporations the right to challenge government regulations and seek compensation if they think they've been treated fairly by any of the PAC Rim nations in the deal. Now, among the more curious of the protests, it's one thing to read an op-ed piece in the newspaper that sort of gives the for and the against, and here we've seen a couple of the contra-arguments, but a very curious action we saw just in the last week or so was by an NGO known as Global Justice Now, which organised a protest outside the offices of the law firm King & Spalding in London. Do we have anybody from King & Spalding in the room? Perhaps we don't, but it would have been nice to have a first-hand or even second-hand report of what happened. But this organisation, Global Justice Now, targeted the offices of King & Spalding in London because King & Spalding has represented numerous multinational corporations in controversial claims against national governments under these investment treaties. And the protest centred on claims of the huge corporate power grab that ISDS would generate under TTIP. And then getting me even more curious, the organisers of the protest carried out an exorcism of corporate power in the offices of King & Spalding, and this was accompanied by gospel singing from the Stop Shopping Choir. Now, that would have been an interesting event to be present at. No doubt there will be some people who will have been there and will be able to report on it in due course, but that was just a couple of weeks ago. Moving on from the perhaps bizarre to the perhaps more mainstream, I've skipped over one slide. No, on the same slide. Professor Stiglitz, of course, the Nobel Prize winner in economics, has also come out in opposition to investment treaty arbitration in the TTIP in an op-ed piece in the Washington Post. And of course, at the EU level, this is being hotly debated as well. The EU hasn't got its own internal position right on whether it wants ISDS at all. And the EU Commissioner for Trade, Cecilia Malmström, just said a few days ago that ISDS has now become the most toxic acronym in Europe. And so you can see perhaps some of the strength of feeling that's being generated by these debates. And it's a very fast-moving debate, and it's also quite fierce. Now, everybody participating in the debate is very well-intentioned, but it seems that the two sides of the argument are at times talking past each other, not directly engaging with the issues. There's quite a lot of ill temper we see in some of the contributions to the debate, and the result is that this debate is generating a lot of heat, but perhaps not as much light as it could on whether we should be negotiating these treaties at all and including ISDS provisions in them. So what I'd like to do today, in the short time that I have, is just give you a bit of brief background on why we have these treaties and what the content of these treaties are. And then I'll look at some of the perhaps more controversial examples that may have given rise to some of this ill feeling, where investor-state tribunals have come out with fairly expansive interpretations, perhaps investor-friendly interpretations of what these treaties mean. And then we'll perhaps look at how some states have begun to address some of the difficulties that are arising in the decisions and awards of investor-state tribunals. So let's move on to what these treaties are. There are over 3,000 bilateral investment treaties or investment chapters in FTAs around. They've been negotiated since the late 1950s. They're historically reasonably short treaties. They're only about 12 or 15 pages in length, at least the original BRTs that we saw negotiated in the first few decades. More recent treaties spell out in greater detail the content and maybe run a bit longer, but at least the original ones, and that's the majority of the treaties we have, are reasonably short. Now, as for the provisions they include, there's about, no BRTs they're not all identical, but there's about half a dozen standard types of substantive protections that are included in them. You may be familiar with some of these phrases: an obligation to provide fair and equitable treatments to investors and their investments, an obligation to accord them full protection and security, an obligation not to expropriate investments unless compensation is paid and other conditions are complied with, an obligation to accord MFN treatment, most favoured nation treatment, as well as national treatment, and then a curious provision known as the umbrella clause, which arguably has the effect of elevating contractual obligations to the level of treaty protection. Now, these are not all new. Just because we have BITs doesn't mean that we've created these obligations. A number of these obligations exist already, even without BITs, as a matter of customary international law. For instance, the FET obligation and the full protection and security obligation are understood to be a treaty reflection of an obligation at customary international law known as the International Minimum Standard of Treatment that developed in the practice of states and claims commissions throughout the 19th and 20th centuries. Now, having run through in a very, very whistle-stop way the content of what these BITs are, let's have a quick look at their history. Where did they come from? Now, what did we do before we had BITs? Now, we did have customary international law, as I've just alluded to. States have always had certain obligations under customary international law as regards foreigners and the property of foreigners to comply with the International Minimum Standard of Treatment, as well as the obligation not to expropriate their investments without paying compensation. But before BITs, states entered into typically bilateral treaties known as Friendship, Commerce and Navigation Treaties, or FCN treaties. These are treaties where states agreed that they would be friends with each other, they wouldn't declare war on each other, they would have trading relations with each other, and each other's ships could use the ports of the other country to facilitate that trade. But these all operated on a bilateral basis, and there were various efforts throughout the 1940s, 50s and 60s to negotiate investment treaty rules on a multilateral level around the same time that the GATT was negotiated in the late 1940s. But all of those efforts fell apart, mainly because states simply couldn't agree on what the applicable rules were. What obligations did states have as regard foreign investment? You can probably imagine that the wealthier, industrialised, capital exporting states had one idea of what the obligations were, but developing countries, which were capital importers, had other ideas and understood that their obligations were less as regards foreign investment. So with the failure of those multilateral efforts, states proceeded on a bilateral basis, and Germany was the first country out of the blocks that negotiated a BIT with Pakistan in the late 1950s, and then other states quickly followed suit. A lot of the negotiating activity took place in the 1990s, of course, with the fall of the Berlin Wall, the fragmentation of the Soviet Union and the former Yugoslavia, and the opening up of markets throughout Eastern Europe and Latin America as well. A lot of these newly independent developing countries needed foreign capital, and they saw the negotiation of BITs as a way to attract that foreign capital because it provided protections for those foreign investors. Now, most of these BITs have investor-state arbitration clauses. Not all of them, but most of them. The first BIT didn't have one, but starting in the late 1960s, BITs began to include these provisions. But what were investors to do in the days before ISDS? Well, they had a number of options. If you were an investor, you had a widget factory in Venezuela or Angola or whichever the country might be, and you had a dispute with the government, you could try your luck in the local courts of the host state. But maybe you didn't really fancy your chances there, because perhaps the courts were not regarded as independent, perhaps there were suspicions of corruption, perhaps you may not get justice in the local courts. Failing that, if you had some kind of investment which was under a concession contract, like a long-term oil and gas contract, you might have been able to negotiate an arbitration agreement in that contract. If so, you were lucky, you may have a contractual remedy under that arbitration agreement. But for the rest of the investors, nothing. It may be that some states had some piece of domestic legislation, and there's only a very small handful that do, which provides for an agreement to go to international arbitration, but there's very few of those countries. Or, as your last resort, you could ask your state of nationality to espouse your claim and assert it on the international plane against the host state of your investment by way of a claim in diplomatic protection. But there's no obligation on your state of nationality to do that for you. It could simply say, look, I think our bilateral relationship with State X is far too important to jeopardise it on behalf of you, foreign investor, with your widget factory. And so we saw BITs as a very important tool of depoliticising these types of disputes and giving foreign investors a means of asserting the rights that they have under these treaties, under international law, without needing to go to the local courts, without needing to involve their own state of nationality, which is why these ISDS clauses are very important for foreign investors, because without them, a lot of the substantive protections are almost ghost protections. They're there, but you as the investor cannot make use of them unless you can get your own state of nationality to bring the claim on your behalf. Without ISDS, the substantive protections, I wouldn't say are useless, but are seriously diminished in value. Now, there's been about 350 concluded claims under BITs, with about 600 or so in total. The first claim was in the late 1980s, and the field has really exploded since then. Let's have a very brief look at two of these substantive protections, and one is fair and equitable treatment. I mean, what does that mean? You may all be scratching your heads. How long is a piece of string? What does it mean to treat it fairly and equitably? That is a very good question. We can have a look at how this provision is included in some BITs. So a very comparatively old BIT of Malaysia is from the 1970s with the Netherlands. You'll see all it says is that each state shall ensure fair and equitable treatment to investments of nationals or companies of the other state party. Fairly vanilla, bare bones obligation. What does that mean? All to be decided in case law. If we look at how some other states have done it, the US-Argentina BIT, this links the fair and equitable treatment obligation to international law and says that international law sets at least a floor below which the treatment by the host state is not allowed to fall. But again, other than that link, it's difficult to see what it may mean. And because of this kind of this bare-bones approach of drafting, tribunals have taken, or some tribunals, not all, have taken quite expansive approaches to interpreting this obligation. So we look at this tribunal. It's a reasonably notorious award now from about just over 10 years ago, the TechMed case. This tribunal said that the FET standard requires the states to provide to investments treatment that doesn't affect the basic expectations that were taken into account by the foreign investor to make the investment. Bearing in mind that is the subjective expectations of the investor, not the reasonable or legitimate expectations. It goes on, the investor expects the host state to act consistently, free from ambiguity and totally transparently, so that it may know beforehand any and all rules and regulations that will govern the investment, as well as the goals of the relevant policies and administrative practices or directives, so that it can plan its investment. Now this, if you take it to its logical extremity, is a stability clause that arguably restricts the host state from adopting any regulation that may have an adverse impact on the bottom line of the investor at all during the life of the investment. It's these types of findings by tribunals that have really begun to raise the hackles of a lot of the protesters we saw earlier on some of the earlier slides. Now states have begun to react to this, and the NAFTA states parties were reasonably swift. They said, okay, FET is to be interpreted consistently with international law. Am I getting the wave? 1 minute? 1 minute. Okay, I'm nearly there. And so we can see that the NAFTA state parties have tried to rein in some of these rogue tribunals, if we might call them that. And here's a tribunal which has come up with, I think, a perhaps more balanced interpretation. But let's have a quick look at some of Malaysia's approaches. In the Malaysia-India FTA, it is also, like the NAFTA parties, tied the obligation to customary international law. And if we look at in the Malaysia-Australia FTA, it has done something similar, but I'll skip over that and go to the ASEAN-China Investment Agreement, which of course applies to Malaysia too. And this interprets FET so narrowly that it restricts it to the obligation not to deny justice to investors in any legal or administrative proceeding. So that is perhaps going one step too far, because fair and equitable treatment maybe should constrain any unreasonable or arbitrary conduct by the host state, but ASEAN and China have made that choice. We're yet to see a tribunal interpret that. Turning quickly to expropriation, which I'll do in all of 15 seconds, this is a standard protection from expropriation in the Malaysia-UK BIT, which doesn't say anything about a number of issues, including the police powers of the state to adopt regulatory measures in the public interest, whether that should be considered a non-compensable regulatory action or whether it's a compensable expropriation. And tribunals have also adopted a number of expansive interpretations of expropriation provisions just like that one, including this, again, high watermark metal-clad decision, which arguably says that if your profits are impacted on at all, that is an expropriation. Other tribunals have said the only thing you look at is what effect there is on the investor. You don't look at the intent of the state and the purpose of the regulation. Now, Again, there has been a bit of a backlash against this, and some states have begun to more carefully define what an expropriation is. And if you look at, this is in the Malaysia-Australia FTA, paragraph 4, a non-discriminatory regulatory action by a party that's designed and applied to achieve a legitimate public welfare objective, such as public health, safety and environment, do not constitute indirect expropriation. So we can see, again, a number of possibly rogue decisions being brought under control there by the inclusion of this international law standard. I'll just go to my concluding remarks so that we have time to hear from Harpreet and Hussain. There are all sorts of other criticisms of the regime that do need to be addressed. I've only given you a very small flavour. There's the whole problem of people sitting as arbitrator and acting as counsel in cases where the similar issues are being decided. There's the argument that there should be an appeals mechanism. There's the argument about lack of consistency. There is a response needed from the international arbitration community if this whole system isn't going to be shut down by the angry voices we saw on some of my earlier slides. For the time being, it's still very live, it's very vital and important. States are still negotiating these agreements. A lot of new claims are still being commenced, 42 in the last year, but we have to wait and see. I think the TTIP and TPP negotiations are going to be really critical in deciding the future of this field of international arbitration. Thank you very much.
Thank you very much, Professor Chester Brown. Sorry to have to rush you.